Good afternoon, Ms. Goldsmith.
Brody.
Ms. McGregor.
Thank you, Lord Brody. Ms. Goldsmith, before lunch, we're looking at some oversight board minutes. There's just one more minute I'd like you to look at, please. It's in bundle 3 at page 87, which is an oversight board minute from the 22nd of August 2019. And if I could just ask you to look on, please, to page 89 and to paragraph 4.2.12.
Thank you very much.
Which says, consideration was given to potential criticism for agreeing to the waiver, but this was felt to be a reasonable step to allow the timeline to progress. Mrs. Goldsmith stated that she was confident and comfortable that the decision to agree to the multiplex waiver would be in the best interest of the public purse and patient safety. There was a good ongoing relationship with the funders, and IHSL had briefed the funders about the works. Do you see that?
I do.
So I think before lunch we were discussing the fact that there was the possibility of a waiver being granted. It wasn't ultimately granted, and multiplex, it didn't take forward the works. But at one point, did you think that a waiver was the right course of action?
I clearly did. Judging by the minute, although I must admit I don't recall that. I think the context would have been the need to get the hospital opened. And I also mentioned earlier in the day that we had established a very good relationship with both M&G in particular and the European Investment Bank. And I did, throughout all of the complexities of the dispute and then subsequent settlement agreement, feel that we had a positive relationship, that they were very committed to not only the hospital being built and open, but they both wanted to have a long-term relationship over the subsequent number of years as the hospital, when it was a live environment. And that was different from, Lothian had a PFI, the Royal Infirmary, and there were something like 11 funders, and it was just impossible to have a relationship. But certainly with the funders of IHSL, I felt that they had the public's interest, patients' interests at their heart. I mean, clearly they had financial, at the end of the day, if the money doesn't work, but they were very supportive, and that's clearly why I felt it was a good idea. But my guess is that it was before we spoke to the lawyers, our legal advisors.
I was just going to ask that. Can you recall why your views changed on the waivers?
It would have been legal advice. Our legal advisors were very crystal clear about ensuring that there was no transfer of risk on the back of the need to get on with the works.
Thank you. Before lunch, you also mentioned in your evidence your recollection that the Scottish Government effectively said to NHS Lothian that the hospital had to comply with published guidance. Did you agree with the Scottish Government view that the new build hospital should be complying with best practice guidance?
Yes, I did. The board had thought it was getting a hospital that would comply with current guidance and best practice.
Thank you. And then just finally, in relation to these miscellaneous issues, in relation to Settlement Agreement 1, we've talked a lot about the multi-bedrooms which were included within Settlement Agreement 1. Can you recall why single bedrooms were included within Settlement Agreement 1?
I think, and I don't recollect, clear, with crystal clarity, I think it was because there was a request to derogate from 6 air changes to 6 mechanical air changes to 4 mechanical and 2 natural.
Thank you. The next set of questions I want to ask you about, they're not really specific about the nuts and bolts of the project. It's really more about reflections and what happens after the project. So if I could ask you, please, to have the Grant Thornton report in front of you. That's bundle 10, page 4, please. And can you just explain to the inquiry what was the Grant Thornton report? Why was it instructed and what was its purpose?
It was instructed so that the board itself could learn the lessons from the project, the capital project on sick children's and the Department of Clinical Neurosciences. There had been an audit commissioned by KPMG not long after we had identified the issue in critical care, and that audit was produced for Scottish Government. They were the commissioner of the report and the client, so to speak. And the board considered that it was important that they had their own independent internal audit to look at what lessons might be learned, but also to try and identify how this had happened, but as equally what lessons we could learn as a board around our systems of control on major capital projects.
Thank you. And if we look on to page 9 and look to paragraph 33, please. Paragraph 33 states, our review identified a collective failure from the parties involved. It is not possible to identify one single event which resulted in the errors, as there were several contributing events. Do you see that?
I do.
Was that your own personal view that this was just collective failure through the project?
Yeah, yes, I suppose until we had this audit, I wasn't absolutely certain, why the critical care element had been missed. There was one version of the environmental matrix which had been changed to isolation rooms rather than critical care. And I wondered whether that had been deliberate and just missed. But clearly there was other opportunities through the project to pick up the issue with critical care. And so until we had this audit report, I wasn't entirely certain what had gone wrong. So the report was really helpful in that regard, that we had, everyone had missed it.
So from your perspective, there's not one single individual or entity that has one catastrophic failure. It's a collective responsibility and collective failure over the whole project.
Yes, so I think it was an error that became sort of embedded in the project, and there were obviously a number of opportunities where we could have, picked it up. Our individuals could have, I mentioned earlier that, I was surprised that the independent tester didn't pick it up. Clearly our advisors didn't, pick it up either. So yeah, there were opportunities, but it was a failure by us all.
Thank you. And if we could look on, still within the Grant Thornton report, to page 39, please. You see that there's a set of recommendations made, and there's also a management response at the bottom. During your time working within NHS Lothian, were you involved in considering the recommendations made and the management response to the Grant Thornton report?
Yes, I mean there was with all internal audit reports, there is dialogue between the internal auditors and the client, so to speak, on ensuring that the recommendations are appropriate and implementable. And so I had been involved in the discussions. This was a really complex audit that took Grant Thornton months and months to complete, because they had to go back such a long way in time to looking at multiple documents. So I was heavily involved through, in liaising with the lead auditor for Grant Thornton and in discussing the recommendations.
And did NHS Lothian accept the recommendations made by Grant Thornton and seek to implement them?
Yes, they did.
And was that process still ongoing in the period up to your retirement? It
was, because actually although, when you see it in black and white, it seems quite simple. The recommendations were the work that had to be done to respond to the recommendation and to improve our systems of control was complex, a big piece of work. The timescale was completely ambitious. And actually, we didn't manage to deliver it to 2020 because we required to have engagement with staff, with clinicians. And as you'll recall, this was during, the pandemic. So we weren't able to engage with some of the key stakeholders to develop our management response. And the other element that influenced how we developed our response and the changes to our system control was the establishment of NHS Assure. However, we had set up a working group with key individuals from my team and other teams who worked through each of the recommendations. I mean, there was already, for example, in our scheme of delegation, we'd already, set out the roles of, as it says here, the SRO, the project director. So we'd already done, during my time, and as capital projects, developed, we would update our systems, update the scheme of delegation. That was something that happened regularly. So when I left, we had already done some work on a framework of assurance, so the sort of broader document that set out, the whole process of capital and how the board would get assurance at different stages and what they required to get assurance on. So that work we'd sort of really got to the first stage of that. And then as I was leaving, that was about to be tested with some either live or projects that we'd completed to test what would we have done differently if this framework had been in place.
Thank
and
you.
there was also dialogue with NHS Assure.
So if you look at the first recommendation, and I'm just reading from 3 lines down in the main box, the problem identified by Grant Thornton was responsibility for decision making on the RHCYP project was not always clear, and there was potentially less of a distinction between management and assurance. That's the problem. And then we see the management response at the bottom in the bottom box, which says that there are already quite reasonable procedures in terms of demarcating senior responsible officer, project director, but the innovation is the 3rd paragraph, a framework for decision making to be developed for capital projects. Yes. Could you just explain in your own words? We don't need to look at the detail of that, but in broad terms, if you already had the scheme of delegation, the roles of senior responsible officer, what was the framework trying to do? It was, so
there are many stages in a capital project, and we've obviously covered some of them, through the course of the hearing. So, there's I've probably got the terminology wrong because things will have changed, but there used to be an initial agreement phase. So you're almost a request to consider a project that's now has a strategic context sitting in front of it, and that strategic context has to cover certain areas. So, for example, within that, you would want to be able to give the board assurance. So there'd be a decision about the project, and there'd be a decision about the options that had to be considered to deliver the board's strategic context. So the board's strategic direction or strategy. So at that stage, you want to be clear about how you've made a decision on the option that you're going to pursue, and you need to be clear about what decision you've made or how the decision sits with the board's strategy. So you want to evidence that for the board. So the board, and you probably just need some clarity on that. Now, I think that clarity was already there at that stage. I think as you get further into the project, areas like derogations, for example, now that's a management decision, but the board would want to be clear about the process of derogations, and you would want to take something to the committee to evidence what derogations had been agreed, potentially. Some of them would be minor and you wouldn't want to flag them, and you would want to evidence how you'd reached that decision and what kind of advice had been received. So that's an example.
Thank you. And I think that possibly also deals, if we look over the page onto page 40, again, I'll just paraphrase in the box at the top, but it said one of the recommendations was that it wasn't always clear, based on the project documentation, what decisions were being made, when and by who, and how these were shared with the SRO through the project board or project steering group. And again, the management response seems to be a process for agreeing and documenting technical changes, stroke derogations, is currently being developed by all capital projects. Again, is that part of the same framework that you've just talked about?
It is, yes.
Thank you. And then if we look over the page onto page 41, just above the bullet points, the problem identified is a framework for clinical engagement not really being in place. And again, do we see the management response? Really, this is where the Centre for Expertise is going to come in NHS Lothian's view.
Well, the board itself, boards themselves will have to have a framework for clinical engagement. So, and I'm now speaking with, not being there, but NHS Assure will, they have they employ some clinicians, but it's the boards that employ the clinicians largely. So the boards will also have to have some framework or some explicit set of rules or standards for using or for asking clinicians to participate in capital projects, clarity about why they're there, what their role is, what their responsibility, what their accountability is for. And clearly, clinical time is quite precious. So at what point do you need clinicians, and at what point are you relying on, for example, if there's more standardisation of guidance, then you don't need clinicians to give advice, on pressure regime, for example, because it's mandated. So boards will still require some kind of framework for clinical engagement.
Thank you. And then if we look over the page onto page 42, one of the issues identified is that the legal advisors tended to give advice that was very formal in nature, captured either through reports or formal email correspondence, and that wasn't necessarily something that was done for other disciplines. And we see the management response there that it's fully accepted that there requires to be more clarity of the role of advisors and their responsibilities at each stage of a capital project. Could you just explain in your words, what did NHS Lothian do to try to put in place that process and procedure?
There is a sort of industry standard, as I recall, on use of advisors. And when I left, we did actually take a paper that set out the roles of advisors, and when you were seeking advice, the situations in which you would be seeking advice, and the difference between that and formal professional advice. I can't recall what it was called, but we did work with our partners in industry to pull together a framework that described the role of technical advisors.
Thank you. And then over the page onto page 43, we see the recommendation at the top. In the case of the RHCYP project, although the project board and then the project steering board had an agreed term of reference, this was not clear about who should attend, for what purpose, and how this particular board was to support decision making. And then the management response is effectively that there was an acknowledgement that there needed to be a gap analysis of membership skills and experience for the strategic project and programme boards. Is that correct?
Yes.
And what at a practical level did NHS Lothian do to try to address that issue?
I think that, to be honest, I can't completely recall. One of the challenges, though, is the NHS is a big, complex organisation with multiple stakeholders. So one of the issues that we were considering is, do you have, and we've tried different models, do you have a very small project board with sort of limited attendance and a much wider stakeholder group? And so that model had been tried previously, but then because of the need to have specific roles and responsibilities and some accountability for decision making, the project boards were then expanded again. So it's quite a difficult model to get right, but the board were certainly revisiting that, and I don't know what conclusion they reached, because I think that would probably be after I left.
Thank you. And then just finally on to page 44, the recommendation is essentially that the roles and responsibilities weren't necessarily always clearly understood on the project. Was the management response, again, back to the framework that we've talked about previously, or was it a different management response from NHS Lothian?
Sorry, what was the...
So I was paraphrasing, but if we look at on page 44,
Yes.
the second full paragraph, just the one above the bullet point, says, based on our review of documentation, the respective roles and responsibilities were not always clearly understood by all parties in the project. That was the problem identified.
This is, I suppose this recommendation is different because the previous one relates to the NHS Lothian employees and those that are going to be identified as being responsible or having a role in a project and some responsibility. This recommendation was in relation to other public sector bodies. So being clear about the role of SFT and the role of the board and the role of government.
Thank you.
In a project, and it might differ from project to project. So if it's an NPD or a variation of NPD, then the roles and responsibilities are slightly different from a capital. Maybe not a great deal, but they're certainly nuanced.
Thank you. And then if I could ask you to look on to Bundle 13, Volume 11, please, at page 93. I think you mentioned in your evidence that there was the Grant Thornton report, effectively the high-level response we see captured in the report itself, and then you thought perhaps towards the period when you were coming towards retirement, there was almost a trial run of some of these procedures on a new planned project. So what we should see at Bundle 13, Volume 11, is a paper for the Finance and Resources Committee from the 20th of April 2022. Do you see that?
I do.
And then if we look to paragraph 3.1, it says that an overall assurance framework has been developed previously, providing a comprehensive approach to assurance in capital projects, together with key suggestions as to how assurance can be sought. From this, a draft checklist has been developed detailing milestones throughout the whole project, the whole of the project life cycle, and the suggested evidence to provide quality assurance. Do you see that?
I do.
So is that the framework that you just talked about that was really had been developed and was being developed? And then if we look over the page onto page 94, again, I won't take you through each of them, but you'll see for each of the recommendations we've just looked at, the recommendation from the Grant Thornton report is set out, and then there's further details of the response and the policies and procedures that had been put in place by NHS Lothian. Is that correct?
That's correct.
And that had been developed and was still being developed in the period up to your retirement, is that correct?
That's right, because I suppose the Finance and Resources is the committee that oversaw the capital projects, but all of this had to go to the board's audit committee, because at the end of the day, the internal audit was commissioned by the audit committee, and the audit committee would need to be satisfied that what we were proposing met their criteria for assurance.
Thank you. The final issue that I just wish to ask you a few questions about today is really on some more of your reflections in relation to the project, and specifically how these potential projects could be done better in the future. So we've already covered quite a lot in your statement and also in your evidence today. You said that you really think that the NPD model is very challenging and perhaps not the right model for these types of projects. Is that correct?
Yes, I do.
What's your views on the procurement model that's used for these types of projects? Do you think the procurement model, as opposed to the contract structure, is fit for purpose?
I think I suppose the first thing to say is that there have been, a number of capital projects developed well, and there's a lot of good hospitals that have been delivered, and the Sick Kids itself is, I don't mean this in an offensive way, but the hospital has been delivered and it's a fabulous facility, albeit there were significant challenges in arriving at its delivery. But in my experience, the best project, or one of the best projects that, in terms of experience of delivering it, was when the contract was with, and I can't recall the type of contract it was, but where there is more of a partnership between the procuring body and the contractor and their supply chain, something that allows a bit more flexibility. I think that is when it's worked best, is that the contract reflects a partnership rather than a black and white, this is what's to be delivered and no variations. So I think and there are obviously contract structures, and that's what I'm struggling to remember the name of it, because we have used it in the past, where you do actually have that kind of flexibility, and there's more of a shared risk between the public sector and the private sector.
Thank you. If I could just ask you to look at one page from the target operating model for the new Centre of Excellence, NHS Scotland Stewart, and if we could just look to bundle 9 and to page 59. So bundle 9, page 59. And you see that at the very bottom there's the box for procurement. Do you see that?
Yes.
So what was identified within the target operating model for the new Centre for Excellence was that the current procurement processes are not fit for purpose. Do you see that?
I do.
Would you agree with that from the evidence that you've given today?
It's quite a broad statement. And so there are, I'd go back to the point I made just earlier, that we have used other forms of contract that have successfully delivered capital projects without the difficulties that we faced on the sick kids. So I think that's quite a broad statement. So I'm not sure about that.
Perhaps if you just help me with one further question, given that it seems to have been identified here in the target operating model for the new Centre for Excellence, in the period up to your retirement, were you aware of any significant changes that were made to the procurement models for these types of projects?
No.
I think within your statement, you touch upon the issue of guidance.
Yes.
And again, a lot of what the inquiry is talking about in dealing with is guidance. It's not a hard-edged legal standard that must absolutely in all circumstances be complied with. The inquiry's heard evidence that the guidance in SHTM 0301, certainly the 2014 version, there were a variety of interpretations. IOM obviously had one particular interpretation, TUV Sud had another interpretation. Just as someone who's worked on that type of project, how difficult and frustrating is it to have guidance that is open to so many different interpretations?
Very frustrating, and clearly it's not, it's not a positive thing to have it as open and variable as that. It does reflect, I think, a different era when actually there was more flexibilities around the clinic. We discussed earlier, that relationship between the build environment and infection control. I mean, that's just one element, but I think the guidance reflects an era where there was more ability, or greater ability for clinicians to influence how buildings were.
And as someone who's worked on these types of projects, particularly from the commercial side, would it be much simpler if there was simply for new buildings, I'm not talking about refurbishing the old estate, but for new buildings, if there was simply a base level set minimum standard, legal standard that had to be met for things like ventilation systems, water systems, all the critical building systems, so that a health board knew that's the bare minimum that has to be met. Would that be an improvement?
Yeah, no, I mean, I think that I think all of us who've been involved in this would say that guidance, some of the guidance should be mandated, and there can't be that much variation between acute hospitals across Scotland and the UK. We're all delivering, the same kind of health care. So that definitely, because it does create ambiguity on, is it guidance or is it not guidance? So I think there certainly should be a set of criteria or standards that are mandated, and others where you've perhaps got a bit more flexibility to reflect local circumstances.
Thank you very much. I think the final question would be, we've obviously covered a lot of ground, both in the statement and in your evidence today and previously at the inquiry hearings. It was just really to ask you an open question at the end. You've obviously had a lot of time to reflect on this project. Yes. Is there anything else that we've not covered today that you think, in terms of improvements for the future, in terms of how these projects could be done better in the future?
I think that the health service needs to invest in, well, needs to invest in a lot. There's no money, but I think as we understand the build environment better, then we do need access to a broader skills, technical skills, than we've had, over recent past. I hadn't really appreciated how complex, sick kids obviously have had to get much closer to some of the technical requirements. So there is a risk, though, that with NHS Assure, you have NHS Assure with advisors and the boards with advisors. And so I think I would support the fact that we need more technical access to more technical resource. But what we can't have is different bodies employing technical advisors who then have got the risk of saying different things. So I think any investment in technical support, additional technical support, needs to be aligned with clarity on roles and responsibilities and not duplication. The other thing that I have learned, particularly through the sick kids, is the importance of good project management. And the NHS tends not to, tends not to train people in project management, or if it does, it's quite ad hoc. When you bring somebody, we brought somebody in from the private sector to be the project director, and I personally learned a huge amount around the skills that a project director or project manager has, and their focus on the project, almost to the expense of everything else, and actually that's a real skill, because the NHS is so operational and it's quite difficult not to be distracted by what's going on operationally, but good project director and project management skills can make a huge difference to the success or otherwise of a project. And I guess the other thing is just the thing that we probably didn't do enough of is the learning from projects. There is a post-project evaluation that's supposed to take place with every project, but you need to resource that, because it can't just be done, it can't be done without people doing it and talking to the users. So I think we all agreed within Lothian that that's something we needed to be better at, is to learn the lessons from projects that we delivered.
Thank you. Ms Goldsmith, thank you for answering my questions. Yeah. I don't have any further questions at the moment. Lord Brodie may have questions, or there may be applications from co-participants.
Okay,
thanks.
Thank you.
Ms Goldsmith, on one or two points, or at one or 2 points in your evidence, I think looking to your previous experience, you talked about the concept of greater flexibility. Could you maybe tease that out a little bit for me?
It's more about the dialogue, I guess, that is enabled in delivering a project. The NPD, the NPD was, we came up with our board construction requirements. Somebody, the contractor designed our IHSL with their supply chain designed, and then it was all fixed into a contract. I really meant that buildings are so complex and the delivery of them are so complex, and the circumstances for each hospital will be different. So in terms of the site that they're being built on, It was more just if we could have a contract that allowed more dialogue through the process of building. I think that would be
All right.
helpful.
Thank you. Mr. McGregor has indicated he has no more questions. What I need to do is find out from the other people in the room whether they have more questions. So if you could maybe give us another 10 minutes or so and retire to the witness room, and in that 10 minutes we'll find out if there's any questions from any other sources. Mr. McGregor?
There is just one question. I think it will just take a couple of moments.
And you will ask.
I'm content to ask it, yes.
I understand we have just one more question. Mr. McGregor.
There's just one question, and it's really relating to settlement agreement 2 and high value change notice 107. Can you remember why single bedrooms in critical care were included within those documents?
This is settlement agreement
2 and high value change notice 107.
because they didn't meet. I don't think it's because they didn't meet the standard. They didn't meet the 10 air changes.
Thank
That
you.
would be why they would be in the settlement agreement.
Thank you. I don't have any further questions.
Okay. Okay.
Thank you, Mr. McGregor.
Thank you.
Now, you're now free to go, Ms. Goldsmith, for, I think, the third time. Thank you very much for this attendance. Thank you again for your previous attendances. But can I thank you especially for the enormous amount of work that preparing statements for the inquiry will involve you in, looking at documents, researching questions. I found your contribution to the inquiry very helpful, and I'm very grateful for it. And perhaps you won't be offended if I say, I trust we will not be seeing each other again in this particular forum. That certainly is the plan, but you're free to go with my thanks.
Thank you very much, Lord Brodie. Thank you.
Mr. McGregor.
The next witness is Matthew Templeton, my lord.
Matthew Templeton. Oath. Good afternoon, Mr. Templeton. I appreciate you've been here probably for a couple of hours now. We try and predict when witnesses will be taken, but it's not always possible to be exact. But I appreciate you've probably been here for some time. Now, you're about to be asked questions by Mr. McGregor, who is sitting opposite. But first of all, I understand you're prepared to take the oath.
Yes.
Sitting where you are, could I ask you to raise your right hand and repeat these words after me? I swear by Almighty God.
I swear by Almighty God.
That I will tell the truth.
That I will tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you, Mr. Templeton. Mr. McGregor.
You are Matthew Templeton, is that right?
Yes.
And you've provided a witness statement to the inquiry.
Yes.
For the benefit of core participants, that's available at pages 208 to 260 of Bundle 3 of the witness statements. Mr. Templeton, the content of your statement will form part of your evidence to the inquiry. You're also going to be asked some questions by me today. If you want to refer to your statement at any point, please do just let me know. If there's any documents that I want you to look at, they should come up on the screen in front of you. So if for any reason you can't see them, please just do let me know.
Okay.
If I could just begin with your background and qualifications, those are set out from paragraph 2 onwards of your statement, but you're a qualified engineer, is that correct?
I graduated as a civil engineer, yes.
But you don't work as an engineer, you now work for a company called Dalmore Capital.
Correct.
And that's a fund management company that holds infrastructure assets to effectively provide returns to investors.
Yes.
And Dalmore Capital invested in the Royal Hospital for Children and Young People and the Department for Clinical Neurosciences.
Yes.
And you've been a director of HIS Lothian since the 15th of January 2019, is that correct?
Yes.
And you still remain in that position?
Yes.
But that, you tell us within your statement that wasn't your first involvement in the project. That's what I mean by the Royal Hospital for Children and Young People. in the Department for Clinical Neurosciences. You say you had an earlier involvement from 2018 to 2019. Can you just explain to the inquiry what involvement did you have 2018 to 2019 before you become a director acting for Danmore Capital?
Certainly. So I've worked for a long time in infrastructure investments, and I had my own consultancy business during that period, at which point I had done some consultancy work through the MSA provider, HCP at the time. And I think the demands of the project at that point, they were looking for additional resources to support to support the project company. I recently had some experience of taking another children's hospital through financial close, through construction, and into operations for patients. So it was deemed I had some recent experience that I could assist the IHSL board in some of the ongoing issues on the project.
Thank you. And just to try to understand the deal structure of the project, you've got the special purpose vehicle or project company, that's IHS Lothian, is that correct?
Correct.
And then I think you said that you the MSA as well. Who or what is the MSA in this type of project?
Yes, certainly. So generally the project company employs another company to run the project on a day-to-day basis, that company being HCP, and they report into the IHSL board.
And the inquiry's also heard evidence that on the project, Bouygues had a role. What was their role in the project?
So Bouygues would be the FM company who would provide the hard facilities management to the project once it achieved practical completion.
Okay. And what would they do at a practical level?
So they look after the building fabric and a lot of the engineering systems, such as we probably talked today, like the ventilation system, the water system. So they maintain the building.
So in terms of the deal structure, you've got the project agreement, which would be between NHS Lothian and IHSL. But IHSL is really just the special purpose vehicle. It engaged Multiplex as the contractor to physically build the hospital, is that right?
Yeah, so I think IHS Lothian is the contracting entity opposite NHS Lothian, but IHSL entered into a number of other related contractual relationships with senior lenders, junior debt provider, Multiplex, the building and design contractor, and Bouygues, the FM contractor. So we bring all of those under an umbrella arrangement, if you like.
So if we just think of that deal structure whereby you've the project agreement at the top, but effectively another web of contracts and arrangements that sit below that, as you say, between the lenders, contractors, those types of entities. Once you've entered into the project agreement and set the deal up, what are the difficulties and complications if you want to change aspects of the deal further down the line?
I think obviously at the point of financial close, if we consider that Multiplex, the building contractor, will have fixed the price and programme for their construction works, I think it's always acknowledged that on these PPP, NPD structures where the concession length is 25 years, that change will occur, particularly in a healthcare environment where, where the treatment changes or new technology changes. So there is generally a change mechanism built in, which is integral to the project agreement to facilitate change. Although in PFI, it can be quite clunky.
Because if you're going to make some of the changes, that has implications for the debt obligations, as one example.
It would only, it depends. If the changes come during the operational term, then they are generally funded by the authority, in this case it would be NHS Lothian, so it doesn't necessarily impact the funding, but as the lenders have security over the asset, then they would have to be consulted and generally require their consent.
And how would changes work if you want to make a change to the project agreement? How does that then filter down, for example, to the relationship between IHSL and Multiplex? So
if it was a change during construction, then that we would just pass that board change down, and during construction, Multiplex are required to develop that change. So they would agree a price in discussion with both IHSL and NHS Lothian on the scope and price for that change. And indeed, there was several changes through the construction period of the project, as there is on numerous PFIs.
Okay. We'll come on and talk about the specifics in a moment, but you talked through the fact that these are long-term obligations. There needs to be some flexibility in the contract structure to allow for changes. What was the particular complexity around about the project whenever one side was saying we want balanced or negative pressure for certain rooms, the other side were saying we don't agree with that, we think it has to be positive pressure? Why did it prove so difficult to try and resolve what seems a relatively simple issue?
I suppose I would differentiate that wasn't so much a change, it was a dispute because the parties had differing opinions on the interpretation of the board's construction requirements. So I think at the time of the project, AVA would be the capital cost of amending the design to meet the client's requirements. But at that point, because we were past the date of the planned date of practical completion, then there was also the financing cost to consider as well.
So does that really come back to clarity in terms of the specification? If you're absolutely clear, if you are the health board, what you want, the obligation is then on the project company effectively to deliver that. But there's a problem if you're not clear and you then fall into dispute as to exactly what the contractual requirements are. Is that, in simple terms, the difficulty that arose?
Yes, I think that'd be a fair characterisation.
Okay, thank you. Just while we're talking about the deal structure, within IHSL, was there the concept of a public interest director?
Yes, so that's a characteristic of the MPD model, that there is a public interest director. So in IHSL, you have the A shareholders who are the investors. So I represent Dalmore Capital as a shareholder, and then is there a B shareholder who is a public interest director who is nominated by the Scottish Futures Trust but appointed to the IHSL board by NHS Lothian.
And the inquiries heard evidence was the whole concept behind a public interest director to try to make sure that there was a more collaborative approach to these types of projects, so that there was someone who had effectively a public sector interest that sat within the project company itself.
I think my understanding is that the public interest director is independent from both the NHSL and the A shareholders. The public interest director, I understand the intent was to bring more transparency to a project company's operations, provide a degree of independence and maybe provide a broader view to some of the project company's deliberations. And within the MPD, because there are specific requirements to maximise the financial surpluses, a role or a task of the public interest director was to monitor the financial performance of the project company and ensure that those surpluses were generated and distributed out to the public sector body, in this case being NHS Lothian.
Thank you. And did the concept work well on the project?
Yes, I think it did. I sit as a director on this and have on another MPD, and I think the public interest director role works well. We've got a good relationship with the PID director, and they generally always, as we all did, endeavour to try and resolve the disputes and in this case achieve hospital opening.
And in terms of the project itself, the individual who took on the role of the public interest director was an employee of Scottish Futures Trust, is that correct?
Yes.
And Scottish Futures Trust, the inquiries also heard, was effectively responsible for the whole NPD model and was providing guidance and support in terms of the project. Do you think there was any difficulties or conflicts in terms of SFT having the role generally to support NPD projects and a specific individual sitting as the public interest director?
I didn't experience any such conflicts, although it's possibly worth inquiry, understanding that there has since been a change where a number of the public interest directors were changed from SFT employees to independent parties. Sorry, not SFT employees.
And the inquiries heard that the NPD model is not taking place anymore for different reasons to do with financing. In terms of revenue-funded projects, is the model still that you'd have a public interest director who's an actual director of the special purpose vehicle, or would that individual simply perhaps sit in an advisory capacity? How are the deals structured at the moment?
So for the existing deals, the public interest director is a director of the company with the full fiduciary duties that other directors would have of that company.
Okay. And in terms of future projects, do you know whether there's any innovations as to whether the individual stays as a public interest director or not, or are you simply not privy to that information?
I don't know, sorry.
Thank you. I'd just like to ask you some questions about the dispute that arose. So that this is really, we're talking about the pressure regime in various rooms within the hospital. On one side, NHS Lothian thought it had to be balanced or negative pressure. On the other side, IHSL and Multiplex thought it really didn't matter. There was nothing specified and it was really to be positive pressures. Is that correct?
Yes.
And the dispute got to a point that there was the threat of litigation made by NHS Lothian. Is that correct?
Yes.
Can you just explain in your own words, from the IHSL side, the letter comes in saying, here's the court documentation, here's the affidavit from Janice McKenzie, the affidavit from Graham Greer. What's happening round about this time?
So I think there had been some sort of mediation meetings prior to them, maybe in 4 weeks prior to that, and we're making good progress with a number of the other disputed items. But I think that we weren't really making any headway on resolution of the 4-bed ventilation. So certainly we received the summons or draft summons from NHS Lothian. I think what was important at that point, or it certainly escalated matters and maybe changed things slightly for IHSL, was that prior to that, both Multiplex and NHS Lothian had both consulted with mechanical and engineering designers to give opinions on their two respective positions. They had both sought an opinion from senior legal counsel, so it was very much, we had engineering and counsel opinion from both sides, which both supported each party's position. But I think what was salient within the court summons was the affidavit from the Health Board's clinical director, project clinical director, was really that we understood better the way in which NHS Lothian wanted to treat patients and cohort patients, particularly in a paediatric environment. And it was also linked to, I think, resourcing around nursing. So I think it became apparent to us that this was, NHSL were absolutely clear that they required negative balance. And it's very difficult from either a design and build contractor or IHSL to counter a clinical opinion like that, because we have no expertise in that area. And if that was a requirement of the Health Board, and certainly, as I'm sure the inquiry I've seen, the letters received, it was very clear that that's what NHS Lothian wanted. So we, at that point, we proposed, without prejudice discussions, to move forward on how we could deliver NHSL's requirements, but within the construct of a settlement agreement.
Thank you. If we just pause there for a moment, you obviously did a degree in engineering and you work as a businessman. Did you find it surprising that when you're talking about guidance, what that means, that there could be such diametrically opposing interpretations of that guidance? On the one side of the debate, you had DSSR offering one particular view, but on the other, you had Rollison's offering a completely different view in relation to the same guidance. Did that surprise you?
I think, in fairness, I'm a civil engineer and we were mainly involved in pouring concrete and things, so we did. So I don't think I've ever really dealt with any systems which would be as complex as ventilation, which is dealing with controlled infection. So I didn't really have an appreciation or an understanding to be able to comment.
But if we come back and think about the board construction requirements, that was what really placed obligations on IHSL as the project company. Did you find it surprising that in relation to board construction requirements that said things like comply with SHTM 0301, that there could be such varying interpretations of what compliance with SHTM 0301 meant?
I think my understanding is that in the board's construction requirements, and when you receive a brief for a healthcare PFI, that it will list out what the requirements are for the different clinical spaces, but then there are generally the riders at the bottom which say you will comply with SHTM, British standards, good industry practice. So they're more almost like catch-alls, but you take it as the actual required, the design brief, if you like, is what you work from, with obviously with cognizance to meeting those various other standards.
And whenever the court documents come in, including the affidavit from the clinical director explaining that the clinical need to cohort patients and why NHS Lothian thought really these spaces needed to have balanced or negative pressure, on the IHSL side, did you interpret that really as a change to the brief under the contract?
From our review at that time, yes, we did consider it to be a change.
And in terms of the discussions that are taking place at this point in time, obviously we'll come on to talk about the settlement agreement, but leading up to the settlement agreement, are the discussions solely focused on pressure, or are the discussions about pressure and other issues such as air changes per hour?
No, I think it's fair to say it was. The pressure regime was the absolute main focus of the discussion. The
main focus of the discussion. So we could look through various emails where air changes per hour are also mentioned, perhaps relevant, but your understanding was really that the focal point was the pressure regimes.
Yeah, I took it that the parties were both agreed that 4 air changes was the correct air change rate. It was just the air was moving in the wrong direction, as in it was meant to be, or the NHSL sought it to be negative to balance to the corridor, where at that time the pressure regime was positive to the corridor.
So from the IHSL perspective, the original brief, as you understood it, was 4 air changes per hour. So if we see references to 4 air changes per hour in various proposals that go backwards and forwards, that's just a continuum of what was always wanted, and it's just simply being tagged on with the change to the pressure regime.
Yes, certainly from whenever I came involved in the project, the two were always stated together.
And in terms of the discussions that take place, you mentioned that the principals meeting that takes place at the Sheraton, I think in the February, resolves some issues, but the discussions continue. March, there's the threatened litigation. Then there's the engagement in without prejudice settlement discussions that continue on. You just try to explain, who are you dealing with on the NHS Lothian side? Who are you having the discussions with?
Initially, it was Jim Crombie and Susan Goldsmith, and then during, I think Jim had to take a period of absence, and then it was Susan Goldsmith I would primarily deal with, but I would also engage with Ian Graham and Brian Curry. But in the majority of the principals discussions, it would be with Susan Goldsmith and Ian Graham.
So they're the principals that you're dealing with. Did they have any advisors that were also involved that were providing assistance?
Yes, it was obviously their technical advisor, Mott MacDonald, but I think in most of the principal meetings, their legal advisor, Mick Roberts, would be their principal advisor.
Thank you. So if I could just ask you to have your statement in front of you, please. So it's in bundle 3 of the witness statements, and if we could look to page 215. Up to this point, you're discussing the negotiations that lead up to Settlement Agreement 1. Just at the tail end of paragraph 33, 4 lines up from the bottom, you'll see that you state, when NHSL and IHSL entered into SA1 pursuant to the project agreement, IHSL and Multiplex entered into an equivalent settlement agreement pursuant to the construction contract which had been negotiated in tandem with SA1. And then paragraph 34, other parties were also involved in the discussions around SA1. NHSL's technical advisors, Mott MacDonald Limited, were heavily involved in the discussions. Do you see that?
Yes.
Could you just perhaps expand on that? Like, what do you mean by Mott MacDonald were heavily involved in the discussions?
Yes, I think what I'm referring to there is really the development of the technical schedule. So those, I suppose, 2 work streams. There was a development of a technical work stream which I wasn't involved with, and then there was the commercial, legal and financial which I was involved with, which primarily involved those principal discussions with Susan, Ian and Mick Roberts.
So the discussions take place during 2018. The inquiries heard evidence that there comes a point where there's broad agreement, heads of terms that are agreed, albeit there's a number of other issues that need to be resolved before the overall dispute is resolved. Is that correct?
I'm not sure I entirely follow.
So it's perhaps easier if I take things to say the settlement agreement is signed in the February of 2019, is that correct?
Yes.
But the inquiry's heard evidence that actually a lot of the works, certainly in relation to the ventilation system, had been completed before the document is formally signed. So I was really just trying to ascertain what happens. February 2018, you have the principals meeting, some agreement but no resolution. March, threatened litigation. And then you get to a point where there's a start of without prejudice discussions, but the agreement isn't signed until 2019. What's happening in that period from March 2018 up to the agreement being signed in the February of 2019?
Okay, yeah, thank you. So in March, Multiplex and IHL put forward a settlement proposal, and key to that settlement proposal was that Multiplex would accept the undertaking of what we were calling without prejudice works at their cost, and they progressed with that. The parties agreed with a settlement that we would all contribute towards providing the 14 4-bedrooms with the 4 air changes and the negative to balanced pressure. I think that came around roughly at the end of March 2018, and I recall there was a decision that obviously because the 4 air changes and the negative balance is the design requirement, if you like, Multiplex then had to engage their design team because it was obviously built at that time to provide positive pressure. So Multiplex engaged their design team and went ahead and converted those 14 rooms from positive to negative to balance. And I think that work was completed around late September, October. There was other events which happened while we were negotiating both the technical schedule and what we classify as the front end of the settlement agreement, where other issues arose on the project, primarily around drainage, heater batteries and void detection. So we had this when we started in the settlement agreement, and we're getting very close to finalising it, and certainly the parties were hoping to enter into the settlement agreement around September 2018 to enable certainly an occupation of patients prior to the 31st of October 2018, before winter pressures commenced. So we were certainly targeting that, but then other issues arose with respect to those 3 items I mentioned, which NHSL sought assurance on.
So the original dispute about the pressure regime, that is effectively resolved at some point by, say, summer 2018.
Yes.
The works are actually physically done, but there are other disputes that arise between the parties so that the formal agreement doesn't get signed until the February of 2019.
Yes.
And whenever the agreement is signed, the inquiry's heard evidence that effectively the certificate of practical completion is done at the same time. So in simple terms, the building is handed over and becomes the responsibility of NHS Lothian. Is that correct?
I think we achieve practical completion, which is the trigger that NHSL can occupy the building, and it would be the commencement of services for the project company and their supplier, Bouygues.
Thank you. At the time that you were negotiating and signing settlement agreement 1, were there any discussions taking place in relation to the need to complete a process called the HAI Scribe Stage 4 before practical completion took place?
I don't know. I wasn't aware of that.
You weren't aware of it. It's not something that's cropping up in discussions, not something that the principals from NHS Lothian are raising with you.
No, I don't really know what an HI Scribe is.
You don't know what HI Scribe is. Is there anyone who would be on the IHSL side of the dispute that would have any knowledge or familiarity with what was required by the process I've called HAI Scribe?
Not the stage 4 you talk about. I think when we do certain works in hospitals, I think it's a requirement to complete one if we were doing any amendments or changes, if we're doing construction works in an operational hospital, but I wasn't aware of there being a process as part of SA1.
It's just, it might be helpful just to look at a couple of documents, because you might be saying, why are you raising this issue of HAI Scribe with me? But if we could look to bundle 1, please, and to page 779. So these are the board's construction requirements. Do you see that?
Okay.
Thank you very much.
And if we could look on to page 800, please. You see that it sets out the NHS requirements in addition to the standards listed in paragraph 2.4 of this subsection C. Unless the board has expressed elsewhere in the board's construction requirements a specific and different requirement, the facilities shall comply with, but not be limited to, the provisions of the NHS requirements, as the same may be amended from time to time. Do you see that?
Yes.
If we look down to letter F, do you see that? It says HFN and SHFN. Do you see that?
Yes.
So SHFN is defined later within the document as Scottish Health Facilities notes. So there has to be compliance with those unless there's a specific agreement otherwise. And if I could just ask you to look at one of the SHFN, so that's Bundle 13, Volume 3. And if we could look to page 464, please. So this is probably not a document that you're familiar with or have seen before, but it's called SHFN 30, and it's Part B of the HAI Scribe. It's a document that the inquiry's looked at before, and I'll take you to the relevant sections of it. And it was really just to look on, please, to page 469. And to the notes section. So effectively, to summarise what this document is, it's guidance that's issued. It's mandatory for NHS bodies to comply with it, and it sets out various procedures to try to avoid healthcare-acquired infections. One of those procedures is the HAI Scribe procedure, which is 4 stages. Stage 4 being needs to be complied with before the building's handed over. Okay.
Okay.
And it was just to draw your attention to the note section. So you see that the note section in the box says this document can provide an insight to the key factors within the built environment which can impact on prevention and control of infection. It is an intended point of reference for healthcare estates and facility managers, designers, project managers, contractors. Now, place just some emphasis on that, and I'll come back to it in a minute. Contractors, engineers, surveyors, health planners and infection prevention control teams working on healthcare estates, new build and refurbishment projects. Do you see that?
Yes.
So again, one of the concepts that comes out of the HAI Scribe process is it's not really just directed at infection prevention and control professionals. Other individuals, estates personnel, contractors, etc. need to be aware of it. From what you've told me in evidence, this presumably wasn't something that was being discussed at all, really, in the run-up to the settlement agreement. Is that correct?
No, not that I can recall.
So this is a document, whether it should or shouldn't have been on IHSL as a special purpose vehicle as opposed to a contractor's radar. As a matter of fact, this wasn't a document that was on your radar or you're considering at the point that settlement agreement 1 is being negotiated.
No, it wasn't.
And it's not something that any of the principals on the NHSL side are raising it during the context of discussions.
No.
We can put that document to one side now. The next thing I'd like to ask you about is, in the period coming up towards settlement agreement 1, what was the financial position of IHSL, the special purpose vehicle? Because at this point, the project is already late. Presumably the funding arrangements are already in place. But until settlement agreement 1 is signed and the certificate of practical completion gets handed over, there's no money that's actually flowing into the special purpose vehicle. So just explain what's happening on the financial side of the deal at this stage in time from the IHSL perspective.
Yes, certainly. So obviously plan completion was in July 17, so there was an expectation in our model that we would start receiving unitary charge from that point, which we obviously didn't because the hospital hadn't been certified as complete. For a period, because our building contractor Multiplex had missed that completion date, they are required to pay what we call liquidated damages, which is essentially in lieu of the income we would have received from the unitary charge, which gives us sufficient cash flow to service our senior debt obligations. And for a period, Multiplex did pay those LDs up to the point that they felt they were required to do so, or they felt it was appropriate they do so because the delay was attributable to them. When we started entering into the amendments around the 4-bed ventilation, part of the settlement deal was, and the share of costs amongst the parties, was to cover the financing associated with the elongated time to make those changes. So I think I said earlier that the parties had agreed that we would target a settlement agreement in September to enable that patient go live date in the 31st of October or prior to. I think it became evident to IHSL in early September that that wasn't going to be achieved, and that did create financial challenges for the project company, because the way it's structured is we make 2 senior debt payments a year, one at the end of March, which we had done in 2018, and then one again in September 2018. So I wasn't a director of IHSL at that time, but I was certainly aware, because I was working with the board, that they had taken some professional advice, and they were certainly monitoring closely the financial accounting of the company, but also they were liaising closely with their creditors, that being the 2 senior lenders, so M&G and EIB. I think it's fair to say both lenders were supportive of the settlement agreement to resolve the disputes and achieve completion, and were assured by the progress that we were making at that point. So part of the funding arrangements is that we have that they allowed us to utilise the debt service reserve account to make that September payment.
And in terms of that point in time, just imagine a world where the settlement agreement doesn't get signed in the February of 2019. What financial risks, if any, would IHSL be facing at that time?
Yeah, there would be the potential risk of insolvency.
Okay.
Should we not be able to make that debt payment?
And was that risk because of the support you mentioned that you had from the lenders and the fact that there seemed to be goodwill on all sides? Was that a theoretical risk late 2018, early 2019, or was that a real risk?
It was certainly a potential risk. We did receive further payments from Multiplex in late 2018 with respect to liquidated damages. But yes, it was a potential risk. But obviously there were options available to the shareholders of IHSL, such as having further discussions with their contractor with respect to the debt on the liquidated damages, or speaking to our senior lenders over any restructuring, or indeed shareholders could have made it.
So should the inquiry understand that this was effectively a known risk on both sides, which perhaps applied significant focusing of minds to try to make sure that there was an agreed resolution before the payments that you've mentioned required to be made?
Yes, I think that'd be fair.
I'd like to look at a document, please. If we could look to bundle 13, volume 9. So just bear with me a moment, please. Sorry, if we could go to bundle 4, please, page 9. So bundle 4, page 9, which should be a letter from Wallace Weir to Brian Curry, dated the 31st of January 2019. Do you see that?
Yes.
And if we could just look over the page onto page 10, you see that it says in bold, all critical ventilation systems inspected and maintained in line with Scottish Health Technical Memorandum 0301, ventilation for healthcare premises. Construction, all ventilation systems have been designed, installed and commissioned in line with SHTM 0301 as required. Systems are maintained in such a manner which allows handover at actual completion to meet SHTM 0301 standards. Operations, all critical ventilation systems will be inspected and maintained in line with Scottish Health Technical Memorandum 0301, ventilation for healthcare premises. Do you see that?
Yes.
Were you involved in the drafting of this letter?
No.
Were you aware that it was sent in late January 2019, or was this simply a different part of the project company to your involvement?
It wasn't a different part of the project company. I just wasn't involved in the response. Although I have since, because I think there was some follow-up correspondence. So after the fact, I learned of the letter.
And do you know anything in terms of the context of why it was sent or why it was drafted in these terms?
Yes, man. Yes. I understood it to be related to events at the Queen Elizabeth University Hospital in Glasgow, where there had been an incident with respect to vermin in plant rooms which had potentially contaminated the air supply going into patient areas.
And a letter going out saying, certainly from the IHSL perspective, their understanding was that everything within the hospital was fully compliant with the published guidance set out in the letter.
Yes, I think, obviously, I think the original letter from NHS Scotland was obviously aimed at operational hospitals because it was very much in the term of making sure the plant rooms were maintained in a cleanly condition and not allowing vermin. But obviously, I think it was issued to the project because we were obviously very close to becoming to hand over. So they were simply checking that and I suppose reflecting on it, because the hospital had been complete for a number of months, you were in a position where Multiplex were actually doing maintenance on the equipment. So it was right that Multiplex should confirm that they were, although they weren't a maintenance contractor, they were maintaining the ventilation equipment to the right guidelines prior to handover to Boyg.
Thank you. So we have this letter that goes out late January. Settlement Agreement 1 is signed in the February of 2019, is that correct?
Yes.
And then you'll be aware in terms of the chronology that the IOM Limited come in and do various testing, and their analysis is that the ventilation system in particular, there are aspects of it that don't comply with the published guidance SHTM 0301, is that correct?
Yes.
Was that analysis by IOM Limited, it's non-compliant, was that accepted by IHSL?
It was accepted by IHSL, but it didn't meet the SHTM guidelines that they had pointed out, but we did consider it met our contract.
It's just that the 31st of January letter, it does seem to be written in quite stark terms that there's full compliance. It doesn't talk about any specific derogations, does it?
Well, I read that, but it was installed and commissioned in line with SHTM 0301 as required, because obviously this letter was from Brian Curry at NHS Lothian, and obviously the previous year we had agreed that there would be derogations with respect to the 4-bed ventilation, with respect to the single bedrooms and the neutropenic. So Brian was aware, NHSL were aware that there was derogations from SHTM 0301, even though we had agreed built those, but we hadn't actually signed the contract to enforce them.
So the as required really meant look back and think of what we've agreed in principle, albeit not documented yet within Settlement Agreement 1, which follows a few weeks later?
Yes, it's certainly documented, but not signed and enforceable.
Okay, thank you. So in the period that comes after IOM do the testing, there's then a period whereby there's negotiations to make changes that actually NHS Lothian, having said we want balanced or negative pressure, then said actually what we want is positive pressure. Can you just explain from the IHSL side, what engagement is there to try to give NHSL what it now says it wants in terms of its interpretation of compliance with the guidance?
I think when the IOM reports were issued, there was an element of disbelief that even after all of the disputes and the engagement and scrutiny prior to SE1, that unfortunately it was wrong. And I think because all respective teams had been through so much and what was quite a complex and challenging project, that we were all very much wanting just to work out what we needed to do to enable the hospital occupation to go ahead as planned in around mid-July 2019.
And was there engagement from IHSL and Multiplex to try to put forward potential interim solutions to make the ventilation system that was installed slightly better than it was as installed, albeit not still fully compliant with NHSL's interpretation of the guidance?
Yes, it was actually quite so. It must have been around late June that the IOM report was issued, and I think we met on around the 1st and 2nd of July. I think there was 2 days of meetings, all party meetings, and at that point there was very good collaboration between all parties. That I think NHS Lothian had advised us that at the existing Sick Kids Hospital, there was a lesser number of rooms than what was being provided in the new hospital. So for transferring patients, we didn't need all of the rooms. So that gave the opportunity to eventually close a four-bed room and close a single bedroom and effectively steal the air from there and divert it into the other single bedrooms and four-bed wards, which I think would move the single bed ventilation from around 4 air changes up to 7, and I think the 4 beds were only marginal, so from 4 to 5 air changes, I think. So that was done early that week, and an instruction received from NHS Lothian to proceed with those works.
Okay, thank you. So should the inquiry understand that certainly from your perspective on the IHSL and Multiplex side, there was a willingness to try to make changes to improve the ventilation system, at least closer to what NHSL's preference would be?
Yes, and sorry, I should have probably said that was very much, the discussions, that was very much an interim solution, because there was an acknowledgement at that point that the 10 air changes and 10 pascals of pressure would need to be achieved. But it was just, can we improve the current conditions by, in layman terms, effectively turning up the fan speed of the air handling units to deliver more air whilst the permanent solution was implemented.
Okay, so just so I'm understanding things, NHSL tell you that there has to be a permanent solution, 10 air changes per hour and 10 pascals of positive pressure, is that correct?
Yes.
That just simply has to be done. But if there's an interim solution that can be done, as you say, by cranking the system up so it's slightly better in the interim, there was also an instruction to do that?
Yes. Let's do the interim first, whilst we develop the permanent solution.
By the time we get to, say, late summer, late August, had the goodwill and negotiations involving Multiplex, had that broken down by that point in time?
Yeah, so I think, so we certainly engaged through the rest of July and probably into August, where we did have, there was a number of technical meetings going on, which I didn't attend, and there was some commercial meetings as well, where I suppose IHSL Multiplex would set out our requirements and the board set out their requirements, because we were seeking clarity on how would these works be implemented, the permanent solution. Because obviously, although we had discussed that interim solution at the very beginning of July, there was then the announcement from the Secretary of State for Health that the the migration into the new hospital was going to be postponed. So the interim solution was then never implemented, and it was just a focus on how do we amend the current ventilation system to meet the new requirement. And we engaged, and then there was technical and commercial meetings to make that happen.
And in terms of the commercial meetings, is that discussing who's going to pay for these matters?
Yes, so it was who was going to pay, and also initially the health board had said that they would instruct a board change, they would pay for the works, but they wanted to reserve their rights. I think at that point, Multiplex are only required to deliver board changes whilst during the construction work. So once you achieve practical completion on the 22nd of February, there's no obligation on your building contractor to do any board changes in the operational period. That would fall to your FM provider. Clearly, Multiplex had much more knowledge of the systems and were the obvious person to go to, and because it was obviously a phenomenal time pressure. So Multiplex said that they would, but they were looking for a waiver of release from NHSL, just essentially confirming that NHSL agreed that the works as built were in accordance with SA1 and were compliant prior to taking those works out and putting new ventilation systems in.
And again, the inquiries heard evidence that at one point in time, NHS Lothian were perhaps amenable to granting that type of waiver, but their position then later changed to a point that they really weren't comfortable granting that waiver. Was that your understanding? Yes,
we certainly, the waiver was offered, and we did have some legal meetings at McRobertson, and a letter of intent was issued with the waiver enclosed. But at a later date, which I can't recall when, that waiver was withdrawn.
So we get to a point in time whereby NHS Lothian is issuing letter of intent, associated documentation. That's on the hypothesis that there was going to be a waiver. The waiver then isn't forthcoming, and is that the point, effectively, that Multiplex disengaged because, from their perspective, it simply wasn't possible for them to move forward with that type of deal structure?
Yes.
And if I could just ask you to have in front of you, please, Bundle 7, Volume 3, page 326. Which is an email from you dated the 30th of August 2019. Do you see that?
Yes.
And it's summarising a call that had taken place with Susan Goldsmith. Do you see that?
Yes.
You begin by saying, I spoke with Susan last night.
Thank you.
Who provided an update of how they wish to proceed following the Oversight Board. Do you see that?
Yes.
And then if we just look to the text just above the numbers 1, 2, 3, you say Susan provided the following rationale for the NHSL decision, which has been ratified by the Oversight Board, and Christine McLaughlin was due to be briefing the Cabinet Secretary. 1, NHSL consider there to be poor engagement from the designers TUV Sud. There's clearly a clash between TUV Sud and NHSL's project team, and indeed Brian Curry has been requesting for weeks that MPX consider an alternative designer. And then point 3, NHSL has a lack of confidence in MPX will resolve the IOM ventilation issues. Do you see that?
Yes.
So is that what you were being told by Miss Goldsmith? Effectively, NHS Lothian had lost confidence in Multiplex's ability to resolve what they saw as the issues with the ventilation system?
Yes, I think just for clarity, so primarily yes. I think just the reference to IOM ventilation issues, although IOM highlighted the issues in critical care, there was a number of other issues highlighted by IOM which Multiplex were continuing to work on. So I think what Susan was saying was she had a lack of confidence that Multiplex would complete those issues on the IOM tracker.
Thank you.
But those were completed.
Then if we look to the second last paragraph beginning, I briefed Ben Keenan. Do you see that?
Yes.
You say, I briefed Ben Keenan on the above, and MPX are considering, although he stated it was highly unlikely MPX will participate in critical care given no waiver is being provided. Do you see that?
Yes.
And again, is that effectively what happened? That negotiations really broke down at this point because of this issue around about the waiver?
Correct.
But in terms of IHSL, did it move forward and engage IMTech, and IMTech in turn engaged Horley to effectively address the issues with the ventilation system to make it have positive pressure and 10 air changes per hour.
Correct.
Just in terms of engaging IMTech, we've talked through the project agreement that's in place. There's still the subcontract with Multiplex. There's obligations that Weeks will have as the hard FM provider. How complicated a process was it in terms of trying to identify another entity that's going to come in and do design and build work on a ventilation system that had already been built and installed?
I think possibly if we take ourselves back to that time, that the project had been in the press quite a lot, so there was a certain degree of notoriety around the project at that point. So there was a limited degree of market interest, if I put it like that way, on coming onto the project and working, although IMTech were amenable, and I'd worked with the managing director of IMTech on another healthcare project, and they were interested in coming and doing the work.
Again, the inquiries heard evidence that really in terms of the deal structure for an NPD contract, you have the health board, you have the project company. The idea is that all the design risk should be pushed onto the private sector rather than the public sector. Presumably then there would be a series of warranties between the project company and their contractor. Can you just talk through why there's not much market appetite for a third party to try to slot into that arrangement late in the day?
Well, I think we were concerned that bringing in a third party, because that would invalidate some warranties, and it would always be difficult if you did have to bring back your build contractor for a defect, because the claim could then be that, well, it was fine when I left it. So I think we were concerned at invalidating warranties. I think as well as it's what I describe as tier one design and build contractors come in to do large acute PFI style projects because of the potential liabilities, where IMTech I wouldn't describe as a tier one contractor, but a tier two or tier three M&E contractor. So they just don't have the wherewithal or financial covenants to take on the type of liabilities which can arise on an NPD project because of some of the payment mechanism and flow down of the deductions.
Thank you. And if I could just ask you to look to Bundle 13, Volume 9, page 335. Which is a letter from IHSL to Susan Goldsmith dated the 26th of November 2019. Do you see that?
Yes.
And if we could just perhaps look over the page onto page 336. The first bullet point at the top, whereby the letter states, with the endorsement of IHSL's proposal to self-deliver and appoint a third party.
I think I'm on apologies. I think my one starts off out of Scottish Futures.
Sorry, so we should be in Bundle 13, Volume 9 at page 336. If we look back over the page, just so you can have the context, back over the page on 335, you see the IHSL letter dated the 26th of November 2019 to Susan Goldsmith, and then it's over the page onto page 336.
Yes.
Which states, with the endorsement of IHSL's proposal to self-deliver and appoint a third party, IMTech, NHSL accepts that the nature of the relationship with IMTech is via a standard construction industry form of contract. We previously agreed that given the nature and scale of the works, limited market interest and challenging programme aspirations, it would not be possible to impose PPP/NPD risks on a third-party contractor. Consequently, we require NHSL to accept that IMTech's liabilities would be limited to standard NEC provisions and cannot, for instance, extend to the flow down of deductions from the project agreement. Do you see that?
Yes.
And is that effectively just summarising what you've already told us in evidence about the difficulties and the position of a third party coming in, what they would and wouldn't accept commercially?
Correct.
So those works are ultimately done. I'm taking Horley come in, commissioning work's done, and the hospital eventually opens. Really, the last thing that I'd wish to ask you is really some of your reflections, obviously being a member of IHSL. This is a project that ended up being years late, millions of pounds over budget. From your perspective, what went wrong and how could any issues be rectified for future projects?
So I think in terms of a delay, I think it could be, and the reason for it, I think it could be characterised in a few elements. First of all, when I joined the project in early 2018, it was already 6 or 7 months behind programme, and that programme delay was primarily due to construction delays at the responsibility of Multiplex. So I think the inquiry's already heard, it was a failed pile. There was 2 subcontractors went into administration, and there was a flood. So flood was later. So some of those were just the construction works took longer than Multiplex had anticipated when they originally programmed the works. I think then when I got involved, it became clear that the hospital couldn't be completed because of disputes with regards to the client brief. And I think certainly reflections, or all parts reflect it, I think it's very important that the client brief is really clear on what their requirements are. And then I think laterally, I think we've also explored that around the guidance can sometimes be ambiguous or interpreted in different ways. But certainly I think greater clarity around the guidance would be helpful, or the guidance could be more clear and less ambiguous or open to interpretation.
Because again, the inquiry's heard evidence from other witnesses who've said it's very difficult to take something that is guidance that's open to interpretation and to effectively shove that in as a contractual standard. You're not talking about a hard-edged legal requirement that a ventilation system must achieve 6 or 7 or 8 air changes per hour. There's no dubiety. From your side as one of the contracting parties, is that a difficulty or a frustration with these types of projects that do refer to guidance which is open to interpretation? Yes, although in fairness, I've never had to pick up that guidance and design anything, so I'm not really. I don't really understand why it's ambiguous or open to interpretation. I just know that there seems to be quite a few instances where it is. And in terms of the deal structure itself, this was an NPD model, but it's not radically different to other PFI, PPP projects. Do you think there's something inherently problematic about using that structure for healthcare projects, or are the issues that cropped up specific to this project because of what you've described as being a lack of a clear brief? Is it a real system problem, or is it project-specific issues from your perspective?
I think the term has a number of PFIs, a number of healthcare PFIs, and I think there's probably over 700 PFIs in the UK, and the vast majority are successful and do deliver the outcomes that the client wants. I think it is fair to say that of all the sectors where PFI has delivered new facilities, healthcare definitely seems to encounter more challenges than any other sector. And I think certainly in speaking to NHS clients that they do have concerns over the inflexibility sometimes of the PFI model, because healthcare probably changes more frequently than, say, education or roads.
So just in terms of the model itself, if there is a problem with it, it might work quite well for certain generic buildings, but whenever you have something that is fluid, science, technology is moving on, it's quite hard on day one to hardwire in what you're going to need over a 25-year project in a hospital building, even if you have standard change protocols.
Yes.
Thank you. The final question that I'd just ask you really is a general open question. You've obviously covered a lot within your statement. We've covered a lot today. Do you have any other reflections or observations drawing on your experience, not just in this project, but on other projects, of how these new build hospital projects could be done better in the future?
I certainly think, irrespective of the model, there certainly appears to be the opportunity for greater collaboration between the designers and the builders, the NHS estates professionals and those clinicians, that maybe create more of a collaborative environment. And maybe if there's and maybe where it does get into difficulties, we were fortunate in this project, sometimes third parties would come in and assist in mediating and unblocking those differences. But I think certainly an environment which promotes greater collaboration between all of those disciplines, which all seem absolutely required to deliver the facilities at the end, would certainly be a positive step.
Thank you. Mr Templeton, thank you for answering my questions today. I don't have any further questions for you at this stage. Lord Brodie may have questions, or there may be applications from core participants. But
Thank you.
Mr. Templeton, I don't have any further questions at this point, but I want to give those in the room the opportunity to raise any points they may have with Mr. McGregor. So we'll, if I can ask you to return to the witness room for maybe 10 minutes, and I'll then be in a position to advise you whether there are more questions or whether or not more questions.
Okay, thank you.
Lord Brodie, just the final issue before your lordship rises, obviously just Professor McMahon was listed for this afternoon. I wouldn't be confident about finishing him in 15 to 20 minutes. I'll make arrangements through the inquiry team to see when he can be rearranged for, but subject to any observations your lordship has, I wouldn't be minded to start Professor McMahon this afternoon.
Right. While you're dealing with the matter of questions, we should ask the inquiry team effectively to inquire after Professor McMahon's availability.
Yes, my lord.
Yeah. I mean, certainly, unless his evidence was pretty brief, I would not be inclined to sit on if it means really going beyond 4:30.
Obliged, my lord.
Right. Okay. Thank you. Mr. McGregor.
Thank you, Lord Brody. Mr. Templeton, there's just one issue that's been raised with me by a counsel for a court participant, which I'm happy to deal with. If I could ask you to look to bundle 2, please, and to page 70. So bundle 2, page 70. There's 2 emails on that page. If we could start with the email towards the bottom. So bundle 2, page 70. The email at the bottom is from Matthew Templeton to Darren Pike on the 3rd of July 2019 at 18:48. Do you see that?
Yes.
And it says, Darren, with regards to the critical care single bedrooms and air change rates, to what extent is that affected by item 13 in the dispute works schedule of the settlement agreement ? This debated whether single rooms, ref to table A1 of Appendix 1, should be 6 air changes per hour versus 4 air changes per hour. However, it was decided upon 4 with an increased extract through the ensuite. With this item 13, single bedroom ventilation air changes was discussed and agreed. Was the intention it also covered critical care single beds, or are these covered under a different part of the SHTM and hence not covered under the SA? Do you see that? Can you just explain what are you raising here with Mr. Pike?
So my understanding is, I think earlier in early June, July, on the 1st and 2nd, after the IOM report had been issued the week prior, there was a number of joint meetings and design workshops to try and find the interim solution. I think that after those meetings with NHSL, it had been raised that NHSL considered that the single bedrooms may not be covered under the settlement agreement. That was what they were considering. And I just emailed Darren to say, look, this is what's been suggested. What's your view?
And then if we look up the page to page 70, you see Mr. Pike sends a reply on the 4th of July, and it says, Matt, reading that through, it would apply to all single bedrooms. I'm checking the SHTMs for specifics around HDU/critical care. Be interested if you / Pinsent read it the same way. Do you see that?
Yes.
And he says that he's checking the SHTMs for specifics, interested in any differing views. Was there a definitive position that you reached with Mr. Pike in terms of what all of this meant?
No.
Thank you. I don't have any further questions. Thank you.
Thank you very much, Mr. Templeton. You're now free to go, but before you do go, can I say thank you for your attendance and the preparation that's inevitably involved in what's quite a substantial statement. So thank you very much indeed, but you're now free to go.
Thank you.
Now, before we rise, I've been giving some consideration to witness scheduling. And the result of that is, subject to anything that Mr. McGregor has to say, that I propose that we sit at 9:30 tomorrow morning with a view to beginning with the evidence of Professor McMahon, who was scheduled for today. And I've taken the view that beginning him would not be very useful. Now, does that sort of fit in with your, well, it probably doesn't fit in with your plans, but is that acceptable?
As has been made clear from the outset in terms of the timetabling, Mr. McLaren and myself have done the best in terms of estimating how long witnesses will take. That's very much an art rather than a science. I think that may have implications as to whether we can get through all of the witnesses tomorrow, but that's something that I'll reflect on overnight. And if we think that there are other witnesses that would need to be moved about, I'll do my best to give as much notice to both witnesses and court participants as is possible, Lord.
Thank you. So if I could ask legal representatives to be available to begin at 9:30 tomorrow morning. Thank you.